5, 4, 3, 2, 1. Start. In the matter before the court, the petitioner has approached the bench seeking the issuance of a writ of appropriate nature for quashing the order passed by the competent authority, whereby the services of the petitioner were terminated without conducting any departmental inquiry and without affording an opportunity to be heard. The petitioner contends that the impugned order is violative of the principles of natural justice and is liable to be set aside on the ground of procedural irregularity and arbitrariness. According to the petitioner, the termination was effected without issuance of any charge memorandum or show cause notice and without recording any reasons whatsoever. The petitioner further submits that the abrupt termination has not only affected the right to livelihood but has also caused irreparable harm to reputation and standing in the professional community. The counsel for the petitioner submits that such action by the respondent authority reflects a colorable exercise of power and is in breach of settled judicial precedents. On the other hand, learned counsel for the respondent opposes the petition and submits that the services of the petitioner were governed by contractual terms and that the same were liable to be dispensed with upon completion of the contractual period or upon occurrence of certain contingencies mentioned therein. It is submitted that the petitioner was engaged on a temporary basis and that no vested right accrued in favor of the petitioner to continue beyond the tenure stipulated in the original appointment letter. The court has heard the arguments advanced by both sides at considerable length. The principal issue that arises for consideration is whether the impugned order of termination was passed in violation of procedural safeguards guaranteed under public law principles. In order to adjudicate upon this issue, it becomes essential to examine whether the nature of employment was such that it entitled the petitioner to protection under the constitutional framework. It is a settled position in law that even a temporary or contractual employee is entitled to be treated fairly and reasonably by the employer, and that arbitrary termination, if effected in a manner that is punitive in nature or stigmatic in consequence, would invite judicial scrutiny. In the present case, the impugned order does not merely state that the engagement has come to an end due to completion of tenure but also makes reference to alleged misconduct without affording the petitioner any opportunity to respond to the allegations. This, in the considered opinion of the court, amounts to attributing fault to the petitioner without following the procedure prescribed for conducting disciplinary proceedings. The court is also of the view that the impugned action fails to meet the test of reasonableness as laid down in various judicial pronouncements. When an order carries civil consequences, it becomes imperative that the person against whom such order is passed is granted a fair opportunity to present a defense. Failure to do so renders the order susceptible to challenge on the grounds of illegality and unfairness. Further, the court finds that no material has been placed on record by the respondent authority to demonstrate that the petitioner was ever served with any notice or given any opportunity to be heard. The requirement of audi alteram partem is not an empty formality but a fundamental tenet of justice. The non-observance of this principle is sufficient to vitiate the decision-making process, irrespective of the merits of the allegations leveled. It is also noteworthy that the service record of the petitioner, as per the documents available, does not reflect any prior warning or adverse remark. The sudden termination, therefore, cannot be justified on the ground of unsatisfactory performance or administrative exigency unless the same is supported by cogent evidence. In absence of any such material, the termination appears to be arbitrary and lacks the foundational facts required to sustain such a drastic action. The contention of the respondent that the employment was purely contractual and thus not amenable to judicial review is also misplaced. The court reiterates that contractual status of employment does not confer blanket immunity upon public authorities to act in an arbitrary or unreasonable manner. Whenever the action of a public body infringes upon the fundamental rights or violates the principles of fairness and equity, such action is open to judicial interference. In view of the above findings, the court is inclined to hold that the impugned termination order cannot be sustained in law. The same is quashed and set aside. The respondent authority is directed to reinstate the petitioner to the post held immediately prior to the issuance of the termination order. However, the court leaves it open to the respondent to initiate proceedings afresh in accordance with law should there be any genuine grounds for disciplinary action, and to conclude such proceedings within a reasonable period by affording full opportunity to the petitioner to defend against any charges that may be framed. The petitioner shall be entitled to all consequential benefits arising out of the reinstatement, including continuity of service and admissible entitlements, except back wages which shall be subject to the outcome of any future proceedings, if initiated and concluded within the time prescribed. In the event no proceedings are initiated within the stipulated period, the petitioner shall also be entitled to full back wages from the date of termination till the date of reinstatement. The writ petition stands allowed accordingly. No order as to costs. Let a copy of this judgment be transmitted to the respondent authority for compliance. Compliance affidavit shall be filed within a period of 4 weeks from the date of receipt of this order. Before parting with the record, the court considers it appropriate to observe that employment under public administration requires the employer to act not merely in accordance with the terms of engagement but also in consonance with the larger principles of justice, equity and good conscience. Arbitrary dismissals without adequate inquiry or justification undermine public confidence in administrative functioning and erode the trust reposed by citizens in institutions. Stop.